This week, the Justice Department announced that they would begin a new clemency initiative that would encourage nonviolent drug offenders in federal prisons to apply for presidential pardons. Deputy Attorney General James M. Cole announced, quote, "We are launching this clemency initiative in order to quickly and effectively identify appropriate candidates who have a clean prison record, do not present a threat to public safety, and were sentenced under out-of-date laws that have since been changed and are no longer seen as appropriate." It will largely apply to individuals sentenced before the Fair Sentencing Act of 2010. That law reduced the disparities in federal sentencing between crack cocaine and powdered cocaine. But it won't be limited to just those people. This initiative is going to be open to anyone who meets the following criteria. One, inmates who are currently serving a federal sentence in prison and by operation of law likely would have received a substantially lower sentence if convicted of the same offense today. They're nonviolent, low-level offenders without significant ties to large-scale criminal organizations, gangs, or cartels. They've served at least 10 years of their sentence. They don't have a significant criminal history, and the list goes on, and you can read the rest of it there on your screen. The Justice Department, they're going to send inmate surveys to determine if they may be eligible under these new standards. Then the Bureau of Prison will take those completed surveys and send them to a coalition group called the Clemency Project 2014. It's made up of groups like the ACLU, Federal Public Defenders, and the American Bar Association. If individuals are deemed eligible, they will be provided attorneys free of charge to help them actually apply for clemency. There are over 200,000 federal inmates, and the department expects to receive thousands of clemency petitions. Eric Holder explained the rationale for this in an announcement on Monday.
As a society, we pay much too high a price whenever our system fails to deliver the just outcomes necessary to deter and punish crime, to keep us safe, and to ensure that those who have paid their debts have a chance to become productive citizens. Our expanded clemency application process will aid in this effort.
To date, President Obama has not issued many pardons. He's actually been criticized for that. He's issued significantly less than Clinton and Reagan, who both granted over 400 pardons, and George W. Bush, who gave 300. This would likely change that. A senior administration official told Yahoo News that the president could grant clemency to hundreds, perhaps thousands of people locked up for nonviolent drug crimes by the time he leaves office. The initiative is seen as a part of a much larger and expansive goal to reform the criminal justice system. It's a goal that has increasingly become bipartisan, with lawmakers and activists advocating for reform in sentencing and also changes within the prison system. In February, when the Senate Judiciary Committee held a hearing to reassess solitary confinement, the panel was comprised of experts advocating for reform from organizations on the left and the right. But conservatives and Republican lawmakers who have supported reforms have not commented on the administration's decision. Some people, like former federal prosecutor Andrew McCarthy, have argued that the way the administration is implementing this by executive order could be troublesome.
Just as the president uses prosecutorial discretion as a pretext for changing a whole bunch of laws he doesn't like, he's now moved on to the pardon power. So the pardon power is going to be his way of rewriting the federal narcotics laws, which he personally thinks are too severe. So it evidently doesn't matter both that Congress has written these laws, that trials have taken place under these laws, and that his core constitutional responsibility is to take care that those laws be faithfully executed.
Joining us now is Marc Levin, Right on Crime's Policy Director and the Director of the Center for Effective Justice at the Texas Public Policy Foundation. Thanks for joining us today. So we know that every president grants clemency, and we just looked at a chart of that. A lot of them do it towards the end of the term. So granting clemency is not necessarily unprecedented, but what aspect of this proposal is unprecedented, and is this something that you support?
Well, thank you. We're definitely still reviewing the details of this, and of course we'll wait and see who is identified and ultimately approved for clemency. But certainly the guidelines are reasonable in terms of the fact that you have to have served at least 10 years in prison. You can't have any violent record either before you went to prison or while you were in prison. So they are focusing on low-risk drug offenders. And I think that one of the things people have to keep in mind is, although the president has veered far afield from his authority in many areas like Obamacare and countless others, the EPA, that the pardon power is one of the most traditional constitutional powers reserved to the president. And President Reagan has pardoned more more people than any subsequent president, at least up until
Right.
now. So I think we should keep an open mind about this.
Does anything worry you about the fact, though, that they're soliciting these applications? It's my understanding that that is something that typically does not occur, but they are actively encouraging people to apply for this new criteria for clemency.
Well, I think you have to keep in mind people that are in prison who have exhausted all their appeals, of course, as of the situation here, this is many years later, they don't have a right to appointed counsel by the taxpayers, and we're not necessarily saying they should. That would be a costly proposition, but as I understand it, these are volunteers like the ABA and American Bar Association that would review these applications. But it's important to emphasize, as I understand it, and we would certainly oppose giving any private, it would be unconstitutional, giving any private entities power to make the decision. They just helping them get those applications together. But ultimately, it's solely the power of the president under the Constitution to decide whether to grant any of these.
I'm sympathetic to this. I know Senator Rand Paul and some other conservatives have also expressed some sympathy for the concept of not putting away for quite so many decades, quite so many years, nonviolent drug offenders. I know it remains to be seen if conservatives will, because we haven't actually seen the final proposal here, come together and say that they're on board for this. Part of my question, though, and part of why I think waiting for the final proposal is a worthy position, a worthwhile position to have, is why is it only limited to crack cocaine? Why is there this specificity in this? Why not just nonviolent drug offenses across the board? It seems to me that this is narrowly tailored for very obviously political purposes.
It will benefit the other people. It's nonviolent drug offenders. It's more broad than that in terms of the 6 criteria they have so far. But just because of the nature of who was arrested for nonviolent drug offense before the law was changed,
I think the answer to that is,
but it's really going to apply to people that have been primarily people that have been convicted for crack cocaine. Why not marijuana? Why not other drugs that also are under Schedule 1 mandatory minimums?
That's true.
Well, I'll go beyond that, but Bernard Carrick talked about he met someone in prison who was there for selling a shark's tooth on eBay. There's people there for importing orchids and seafood that didn't meet the specifications. These are people we need to absolutely focus on.
I think it's also because, Buck, there's a more narrow disparity and a more narrow, what is actually a discriminatory effect in those laws. We can all agree, or I don't know if we all agree, but we can agree that the nonviolent drug offenders have been suffering under mandatory minimums for quite some time. Fair is not a word I like to employ very often, but it doesn't seem just.
It's unjust. I think that's
right.
The right way, yeah.
But the crack versus powder cocaine disparity has also been something that people have been talking about for quite some time, that the same amount of crack is punished much more heavily than the same amount of powder cocaine, and that's a place to start their suggestion.
Okay, as long as it's a starting point. I just think this doesn't go far enough, quite honestly.
2010 law basically said it was a 100-to-1 ratio of crack to cocaine, and now it's 18-to-1. So there's still that disparity because crack is obviously involved in more violent crimes. But here's my question. I think it's a very difficult issue to balance mercy and justice, and this sounds reasonable to me, but what happens? What happens when some of these people who are released, who had no records, go on to commit violent crimes and otherwise would have been in jail? Isn't there a huge political blowback if someone who doesn't have a record goes out in the streets, would have been in jail had not been for this program, and they go out and they murder someone?
There could be. I don't want to be the anarchist.
You release 10,000 people, you're going to have 100 of those people are going to go out.
The statutes are
but the argument is we unjustly punished you, and we're afraid that you adopted some bad habits during our unjust punishment, so we got to keep you locked up.
I agree, but we should be aware of what we're getting into, and I think that the just thing to do is just be aware of this, but I think it's going to be a huge political blowback when this happens.
Absolutely.
Furthermore,
if it
slips through the cracks.
Politics, but let's be clear, politics is what got us here. Politicians wanting to look like they're tough, keeping society safe, keeping communities safe, meant they were locking people away for as long as they possibly could under mandatory minimums, specifically so that they could get reelected, not looking at what it does. By the way, these people eventually do get out of prison, and many of them have no life to look forward to because of the very laws that
It's the way that he's doing it's the way he's doing it that is wrong, and it fits in a larger pattern of Obama's behavior that goes to the very heart and threatens the Constitution. He did this on education, first of all. You have a No Child Left Behind Act that punishes way too many schools, is way too strict. So what does Obama do? Instead of rewriting the law, he starts granting waivers. We have an immigration policy.
Pardon is an executive power.
We have an immigration policy where presidents for years, Reagan, Clinton, name any president, they have all said, for example, when there's a disaster in Haiti, they will let some people into the country on a case-by-case basis. However, Obama's DACA program is a legislative,
those are drastically
systematic
different, though, because of the narrowness of this. And I think to Buck's point earlier, Buck said, why doesn't this apply? Yes, it is, because I think it primarily, when you look at it, does what Buck says. It applies to people that were prosecuted under the crack cocaine discrepancies, which is a drug that once it hits the bloodstream, has the same, but still the point is that it is primarily narrow to that. And I think you could point to this and you can say, is this actually an effort to overhaul criminal justice reform, or is it trying to correct the past
beyond that?
wrongs
It's a simple
that people
rebuttal.
think
Both the
was
guest and Buck
racially-
have said it. How do you respond to someone saying the pardon power is clearly there for the president?
And by the way, in apples
Immigration enforcement has always been a priority.
I
of
just-
generation.
one
but
quick
it's
one.
it's the legislative nature of implementing a whole new system by fiat, which is normally done through Congress, that is different than normal.
You're not
past
comparing the same
pardons.
things. An apples to apples comparison would be President Obama saying crack cocaine no longer gets you sent to prison. We're just going to completely violate the whole law. We're going to say it's not there anymore. This is, if you've served already, this is clemency. This is under the power of the pardon. This is after you've served 10 years.
When you have someone like, President Clinton pardoning Marc Rich, that's a classic, pardon power. When you have a governor looking at someone on death row, looking at the facts of a single case, that is a classic.
What about draft
That
dodgers?
is a classic.
That's the question.
What about draft
President
dodgers?
Obama's not himself signing off on this.
That's-
Who's the
Mark,
bureaucrat?
Our pardon.
The DOJ signing off?
Ultimately, Obama won the whole.
Mark, let us bring you in on this. Do you think that this is an abuse of the pardon power, or do you see this as being consistent with how it is typically used?
Well, yeah, I think the Marc Rich thing was actually an abuse, but this is focused on people that have met all these criteria, and even then they were not guaranteed. They have to apply. So again, we have to wait and see exactly how this works. But I don't think anything in the criteria that's been outlined is really troubling. The thing I would say is that they need to look at how can these people perhaps be put on supervision after their release, so that there's some monitoring to make sure, hopefully, that they don't get back involved in drugs and any other negative activities. So that's really should be a focus of this, I think.
All right, well, Mark, we appreciate you giving us your time tonight, and I'm sure we'll be discussing this again once we find out more about it. The federal government finally got around to regulating e-cigarettes. Levin explores what it means for your nicotine fix in tonight's Q&A.